Okay, criminologists and future criminologists, the topic for today is the continuation of Republic Act 9344, which is our juvenile justice and welfare. Well, of course, did we discuss anything, or we have discussed all the procedures, all of the efforts of the government and their efforts to try to limit the occurrences of juveniles or child in conflict with the law here in the Philippines. However, because of those efforts, uh, they still have their problems that are being encountered when it comes to dealing with these minors. Now, these minors, even though we try to protect them at their best interest, the government tries to protect their rights, there are still children who are not able to do what is being required by the law. So in cases that children still commit these offenses, in cases wherein children commits crime, there are still procedures that we need to follow. So as provided for Republic Act 9344, what is this referred to as the taking of custody of the child in conflict with the law by the law enforcement officers or the private citizens? Because even though we try to prevent crimes at our most effective ways, still there are children who are able to do offenses or able to do crimes. So first thing that will be happening to them is to take into custody, or that is in simple layman's term, it is arrest. However, there is no such thing as arrest in the juvenile justice, which is provided by Republic Act 9344. They call this one as the initial contact with the child. Now, this initial contact with the child could either be performed by a private individual, well, of course, as part of citizen's arrest, and it could be done by a police officer as part of his job. Now, however, what are the things that you should remember is what you call as the prohibited acts provided for by Republic Act 9344. So what are these prohibited acts provided for by 9344? This is branding or labeling, okay, of the CICL or any forms of discriminatory remarks, okay. So you will be automatically telling them that they are criminal is an example of branding, that they are not allowed to be branded outrightly as criminal because there is still a due process which the law provides. As threats is another example, telling them any kinds of threatening words to kill them or to punish them or to kill them in cases they do this or do that one. These are all not allowed by law. And then abusive or coercive or punitive measures. Okay, any forms of abuse, slapping, okay, pinching the ears, okay, pulling the hairs are some of the abusive or coercive or punitive measures that is not allowed by Republic Act 9344. Degrading or any forms of inhumane or inhuman or cruel forms of punishment, such as putting them inside the sack or having any forms of punishment that are not acceptable because they are yet a person to be investigated, and you are not, the police officers are not allowed, or even private individuals are not allowed to render or provide punishment to these children or compelling them to perform involuntary servitude. Or example is that after apprehending the person, you let them massage you as a part of their punishment, are not example of good punishment that's to be provided to them. That is a form of involuntary servitude. Well, remember that 9344 protects the children. The rule on juvenile in conflict with the law, first is to take custody of the child, the taking of the custody of the child. So that is purely in criminal justice system, that is a form of arrest. But in juvenile, we take, that is termed as taking the child into custody, or CICL as custody. Well, we defined already CICL, child in conflict with the law. A person who is below 18 years of age, adjudged of alleged of committing any forms of offenses. Now, initial contact is also known as the apprehension or the taking of person or these children into custody by it's either the law enforcement or private citizens. Law enforcement as part of their job and private citizens as part of their right as bestowed to them by the law as part of citizens arrest, as we have mentioned. On citizens arrest, this could be lectured or this is lectured on other slides or other videos that we had. Kindly search them. Well, it includes the time when the CICL receives subpoena. So it does not mean to say that arrest must be the taking of the child into custody. It includes the time he receives subpoena or orders or any forms of letters coming from a court which has jurisdiction over his case is a part of initial contact with the child. It does not always mention that taking arrest means there should be an actual restraint of the person. Okay? Or summons from the prosecutor's office is an example of initial contact. Okay? For private citizens, they are allowed to take custody of children, okay, but must immediately refer the child to any law enforcement officer for proper investigation. So upon arrest, me for example, as part of as a private citizen, if I have able to arrest a child in conflict with the law, I am to submit or I am to refer this child to any law enforcement officer for a proper investigation. Now, as part of the duties of the law enforcer during initial contact with this child, you first, of course, need to identify yourself. So, for example, I am Police Officer Jimmy Caltino. Yan. I am arresting you for the crime or the nature of the accusations or the crime against him. Then inform the child, of course, of his constitutional rights, that even a child has their own constitutional rights, which is the Miranda Doctrine, or under the case or study diseases on this Ernesto Miranda versus Arizona. And explain that to the child what is the reason why did you apprehended him. He has the right to be informed of his right as part of his Miranda rights or his constitutional rights. And then, of course, we need to refrain from harassing or abusing the child in any form, at any form, because even the simplest forms of undoing or immoral or punitive actions that is not prescribed by law is a big mistake, is a big no-no if we try to arrest the person. And of course, within 8 hours that the parents, the guardians, or the LSWD or the DSWD or any social worker or the public attorney's office must be notified by the law enforcer. That is within 8 hours when the child is taken into custody. We are not following the rule of 12-18-36 when it comes to light, less grave, or grave penalties. Okay? That if you violate that, it will become arbitrary detention or illegal detention. Okay? For children, it is automatically within 8 hours. So what happens still within 8 hours? Within 8 hours that we are able to determine the age of the child. So how again to determine the child? It is located in our one of the videos. Kindly go back to it. Yan. Take the child into the medical officer for physical or mental examination. For physical and mental examination, the purpose is that for physical, we need to prove that the child still has really the intact physical occurrence or physical nature, that the police officer was not able to abuse these children, or in cases where there are previous bruises or previous forms of wounds that the child has incurred before the conduct of arrest, will at least be recorded for proper recording purposes, and the police officer will not be made liable for it. And then, of course, mental examination to be able to identify whether the person is insane or insane, as part of determining whether or not the child has acted with or without discernment. Okay, again, discernment was discussed on the first video that we had. Would you try to please take them first? And then avoid use of firearms, or even the law says display of firearms or any instrument which there is a show of force or restraint. Okay, unless of course it is absolutely necessary. These are the things that are to be remembered by the law enforcers. They are not allowed to do these kinds. If detention is necessary, if there is a need to imprison the child, separate these children from adults. Remember, Republic Act 9344 was created in 2006 because 2000 to 2005 there were a lot of children who joined the adults, and the result is that they are being brainwashed, they are being educated on the adult thinking of those persons who are in jail likewise. So, Republic Act 9344 tried to separate these children from the adults. Okay? And then, the use of handcuff or other instrument or restraint should be recorded. The notification of the parents, and then measures taken to determine the age of the child. So, how did you come up as a police officer conducting initial arrest, come up with identifying the age of the child, and then ensure that the statements signed by the child are witnessed by, of course, the guardians, parents, social worker, or the legal counsel. So any forms of records that they need to sign within your office as a police officer must be in the presence or witnessed by the parents, the guardians, social worker, or the legal counsel. So there must be the presence of either of these. It's very important for your safety also as a police officer. And then the search on the child to be conducted is to be performed by the police officer with the same gender. So for example, the CICL is a female, then he must be searched by a female, or the other one is on the vice versa. So of course, after initial arrest, there is the initial investigation. And in initial investigation, this is the stage after the initial contact when the law enforcement takes the statement of the child. So this is the time wherein, of course, any statements when it comes to the preliminary or investigation of the police officer must be assisted by the DSWD. Okay? So that is the initial investigation to be conducted after initial contact. The law enforcement officer shall make the initial investigation by taking the statement of the child in the following manner. The police officer must remember the following. Number one, it is to take this statement in the language that it is understood by the child or by the CICL. It must be, you cannot ask an English question to a child which is not an American, or who is not able to really understand what are these kinds of English speaking that you have done. Okay, it is first important to do this in a friendly manner or in an non-intimidating manner. Well, of course, the children, you are to take a best evidence, then you do the best thing, which is to avoid intimidating the child. So be friendly. Okay, this must be conducted in a room or place where the child is, of course, comfortable. Okay, so in what place can the child be comfortable is a place where the police officer can conduct his initial investigation. Okay, and then it is the privacy that must be observed. The thing that we should remember when you conduct or take the initial statement is that you should take the statement, okay, in front of the child's counsel of his own choice, okay, or in the absence of any lawyer, the public attorney must be present. The parents or the parent of the child, the guardian, custodian, or any local social welfare officer. And remember also, it says here that the name of the child is not allowed to be disclosed, even by the police officer. And also remember that all the records and proceedings involving the CICL or child in conflict with the law, okay, must be privileged and confidential. So privilege meaning to say a person only allowed to browse these records are to be given the permission to see or to look. They are not even treated as public, nor private, nor official forms of records. They are privileged and circumstantial. So for example, one question is here. Mr. Di Fatule had a previous record being a CICL. After his case was resolved, he applied for the job. On the forms that he is required to submit, he denied under oath that he had a record of being CICL. Can he be charged of perjury? So you can see here up that it is no. Okay, why? Because of course the children's records, the child record is to be treated with utmost confidentiality, and it's already privileged and confidential. So he cannot be charged of perjury. Okay, so if the child in conflict with the law has willfully failed to comply with the conditions after his disposition or rehabilitation program, the child in conflict with the law shall be brought before any court for execution of judgment. Remember that if hearings, if all the trials have been conducted, is that it is resolved in favor of the child. Well, what if the child has failed to comply with all the requirements, with all the conditions given to him by the court for his temporary freedom while waiting for his case? Is that to bring the child or bring the child before the court for the execution of judgment. Okay.